I wake up tired. I slept all night. My eyes ahead. I have no sight. My pockets empty. My wallet's dry. I can't afford a penny. I'm a broke guy. I'm tired of this fucking shit. I'm tired of this fucking shit. This shit I can't stand. I'm tired of this fucking shit. I saw the girl I love. She's with another guy. They just hugged. I asked the man above why. I bought a new shirt last night. I went out, got in a fight. I told her fucking collar, now I don't have a dollar. I'm tired of this fucking shit. 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 Yo, equal and the same. Smash the chains. Hammer and Hank. Ada unbreakable. CPA's crumbling. Bomb detonating. Rough. What? Yo, we equal and the same. No damn chains on our flame. CPS, demon scheming, playing very twisted game. Hammering Hank, pounding hard. Shattering the frame, fighting for blood rights. Igniting the blame. Ada warriors rise up fierce. Disabilities to fight or curse. Equal under fire, no retreat, no reverse. They divide and conquer, label us lame. But on a podcast, we unleash the hurricane. Equal and the same. What? We demolish CPS. What? Hammer and Hank charges. Ada invincible. Equal and the same. Explode the bomb news. People with disabilities, warriors unleash. We seize the truth. Unleash beast. Snarling at the beast system, they caging in rage. But Hammer and Hank crushes the stage with savage rage. Podcasts erupting like a nuclear bomb. CPS horrors exposed, calm before the storm. Hell no. Ada armor for the bold and the scarred. People with disabilities, stars in the yard. No inferior labels, we clash in the night. Hammer and vengeance till the dawn's brutal light. Equal and the same. What? We demolish CPS. What? Hammer and Hank charges. Ada invincible. Equal and the same. Explode the bomb news. People with disabilities, warriors unleash. We seize the truth. Unleash beast. Lord, feel my fury in this infernal war. Equal and the same, we even the score. For every disability crushed and denied, hammering Hank obliterates with 8-8 tied. Podcast mic scorching, breaking news bomb inferno. CPS imploding, truth's eternal bad. Equal and the same. Smack. We demolish CPS. Crush her and Hank charges. Everyday invincible. Equal and the same. Explode the bomb news. People with disabilities, warriors unleash. Seize the truth. Unleash beast. Victory. Victory. Victory.
When the courts aren't blue saying fair, you have pulled out your last hair. The law isn't on your side. These corrupt judges take you for a ride. The courts don't want to even oppose. That's how we know it's corrupt. My disability has a name. We're all equal and the same. All alone in the courtroom floor, waiting for your hero to bust right through the door. It's hammering Hank every time. He's the one towing the line. Hammering Hank, he fights for the weak. there for you if you can't speak. Hammering Hank is the eyes you don't have. Hammering Hank, making sure you're not last. In the court they do have rules. They don't treat you like your jewels. You deserve all the commodities just because we have difference in our bodies. The law is made for us all. They don't protect us that have files on. He's the answer man you need to be calling. He puts it to an even field. Hammering Hank, he fights for the weak. Hammering Hank, there for you if you can't speak. Hammering Hank is the eyes you don't have. Hammering Hank, making sure you're not last. When you're a bit different, to phone you free. The playing field is equal, what do you bet? That judge has to toe that line. The oughta make sure every time. Hammering Hank, he fights for the weak. Hammering Hank, there for you if you can't speak. Hammering Hank is the eyes you don't have. Hammering Hank, making sure you're not last. Hammering Hank. Hammering Hank. Hammering Hank.
Well, hello, everyone. Welcome to Equal and the Same. I'm Henry Martocchio. It's 6/20/26. Again, we apologize for us being late. The team backstage was working on a document that I'm trying to achieve for everyone, not just myself, but it would be a document in regards to immunity. Immunity of state actors, state players, bar members, DCF, police, doesn't matter. They're a Title II entity. They must give modifications to policies and procedures to ensure non-discriminatory policies and procedures are in place. They must have an affirmative duty to point you to direction, and they must publicize this by name, and the publications must be easily acceptable in different formats. I don't know. I'm playing with this whole thing, on judges' immunity. I get we can get everyone in their administrative duties, but, when you take into the fact that judges go through anti-bullying laws for employment, they have their own employee handbook, which, should mandate that they can't discriminate within their duties. And what I call discrimination is when they deny you the rights to access Tennessee Lane, which it's already been constitutionally ruled on. I also have Popovich, which is a Title I application. I also have Reed versus Illinois, which is I think 2019 case. But the most one is Mulberry versus Madison. If the state cannot make a rule or policy or enforce a rule or policy that denies you your due process rights, and most of all, how can they rule on their own discrimination? It just blows my mind that we're sitting here today using systems that do not have their administrative duties complied with, and it becomes a systemic discrimination, which again, that would be in administrative duties. But I think they have affirmative obligation underneath their prophylactic protections and strictest scrutiny standards to ensure that everyone has a 14th due process rights. And again, when you look at the entity as the government as a whole, it's different departments within, and to tell me they don't have the expertise within that department, they can definitely jump over budgetary lines and fix the needs and rights of the disabled to have effective communication, to have access, to have program success as if they had no disability. But most of all is not to allow anyone to use their disability as an excuse to deprive them of some kind of right, or keep them from community inclusion. And you kind of find that in the Olmstead decision, which again, if it all look at these program service, even Title IV funding, guys, it all ties back to the Department of Social Services within your state, or maybe public health. They should have an input on it too. But we also have the Department of Education, where if you're in an IEP meeting, they give you your 504 due process compliancy notice. And in that notice, it spells out XYZ. And guys, remember, anyone an IQ of 70 and above is forced to be in society, working, having family life, the whole nine. Anyone with an IQ of 69 or less, they typically racketeer them into guardianships, which if you get a chance, learn about that on probate court if you need to. I think it's the same as what they're doing with adoption. I think that pulls out of that type of scenario. For, we'll just say that their techniques in undermining this to get the federal funding, but not give the program services and activity. Because again, if you remember back to the purpose of the Title IV funding, 1938, it was to keep families intact. But now we're using it 100 years later to twist it and segregate for profit, and ensure that the disabled people are persecuted for having disabilities. But anyways, enough of me blogging. I would like to show my two co-hosts tonight. We're going to be dealing with immunity in the ADA, the 504, Title VI. It all ties back in even to Title VII. It's a fundamental constitutional right. That I just feel that, when a judge is in the acts of their duties and you've identified to them your rights are being violated in the court process, it's very clear in Tennessee Lane, things must be stopped, and the judge must make a determination on whether or not the service is appropriate or not, whether or not you've had effective communication, whether or not you've had the interactive process as an administrative duty. In that interactive process, I furthermore argue, well, if you know your job, then you're going to know what accommodation you need to do your job. One, when we walk into these program services and activities of DCF or the courts or, divorce courts, I don't care what it is, Department of Developmental Services, you're bomb shocked. You need technical guidance, and this is why we go out of there with certain things. And all these notices that are on there says they comply with the ADA, but yet when you look into it, they're referencing you back to their HR department, which, again, without the designation, I don't get how the HR department could be the entity, because in Rikers Island clearly says it's a person. They have to be qualified. You must publish their name. They must, give the affirmative responsibility to correct the entity's discrimination if cause and effect was involved. So again, the funding must be there. So that means they have to have a financial burden or training, or, in my opinion, I believe the designated responsible employee, let's just say for judicial, has the right to over monitor not only the judges in the courtroom, but also the attorneys. Because without the courtroom, the Bar Association is basically a inner organization appointed by the state that, in my opinion, is a monopoly, because, again, they have the whole thing cornered where you cannot question their legitimacy of billing and what the cost is in the whole 9 yards. There is no consumer protection involved. You get continuous billing by the hour. You're done. They always go through the retainers. Oh, first you got to give me a $5,000 return, and then we're going to see where we're at. And of course, you chew through that money within 1 week. Them just getting documents in the whole 9 yards. Yeah, so I don't know. I'm babbling now, so I guess it's time to bring in Darren to rescue me and Becca because they were the co-workers, and I know Darren's got a copy of what I've done. And if you could pull that up, Darren, that'd be great. Um, or what we've done, I should say. Um, you there? Oh, there you are. Thank you for the new song too in the beginning. Can't hear you.
That was our old one. Remember, we did that a long while ago. Um,
Okay, but how you doing tonight, sir?
yeah, I'm doing. We had a good day today, Henry. We worked a long hard day for on your documents, and they've come along a long way.
Well, it ain't our documents because what my feeling is we
Well,
got to get this
yours.
out there because if we don't start preaching this again, the only settlement agreements I see or facts of federal government stepping in is when it's abuse of financial dollars. So that's how we got
That's
to
all
start
they care about
shifting
at
these
all.
guys.
That's all they care about, Henry, is money, 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 money.
Money.
They don't give a shit if you're hurt, if you're injured, if you're upset, if they've broken the law. They don't care about that. When it comes down to the dollar, Henry, that's it. That's where
And
it all matters.
Federal Rule 11 says the federal judge has the authority to determine whether or not this is vexatious litigation. Are you kidding me? If I can't address my civil rights here, you know what I mean? How do I get them addressed if federal funding is behind it and you won't hear the merits underneath false claims acts?
Well, $12.8 billion in your state a year, right? That's what we come up with.
I believe that was in one program, and I thought that was in the Department of Child Support Enforcement and child. What was it? I forgot what it was. We didn't flush out the whole
I think
state,
that
but
was
it
the
is.
whole is what the ADA gave. They gave them the state in a whole. That's what I thought. But I mean, that's a lot of money, and if they're not compliant with what they're supposed to be doing, then they need to give that money back.
Now I've read it in DOJ's guidance, and I cannot find it because it's stupid ass. When you read something good, you guys got to set it aside, and you won't know it's good until after you read it. And you said, "Holy
Right.
shit, that just made me think." But an example of it is, the state cannot, if you're offshore drowning 10 feet, the state cannot throw you a 5 foot lifeline and say they've done their job. They have to actually send you a rope that's 11 feet long to ensure it gets you to your goal of rescue. So
Okay.
when we're looking at program services and activities, and another good one is basically they've said, you know, that the state takes so much funding from education all the way to highways, bridges, hospital grants, parks, you name it, everything. How does the state get to say that they don't have the right for daddy to talk to them and say how it is? Because basically, when you're on state services, they use that same analogy. Well, we're the parent, we're paying for everything, so you're basically going to do what we're saying.
Yeah. I don't
It's
know.
crazy,
I don't have answers for everything. That's for sure. And I don't
but
I don't I don't even pretend to. But what I do know is that there's disabled people out there in this world right now that need the assistance that our government, our federal government, has paid for, that they are not getting. I mean, that's the overall thing here that we need to focus on is the fact that there's $12.8 billion. Now you times that by 50, just times that by 50. You got a little piece of land over there in Connecticut. Imagine that the remainder of the other 49 states that we have here, um, times 12 billion times 50. What do you got? $600 billion. $600 billion of government spending. And how many disabled people are out there right now going without? That's the
and
question
to
that
tell
we have.
me they cannot follow Congress will that again it's 42 USC. It's in my documents, guys. I'm sorry, I'm brain frogged. But it basically sat there and said that no disabled person shall be discriminated in any state program, service, or activity. Then again, we have Tennessee Lane, and we have Popovich, then we have it just goes on, and we've been having this argument all day. We got them in their administrative duties. That's all day long, guys. We'll tell you that right now. I'm playing with the fact that I cannot see until 1857, and it was a case where the United States Supreme Court gave themselves immunity, and basically it was a case on whether or not the government, can legally
Well, let's
own.
not know because the immunity, Henry, the immunity came from the common law, the common law pleas of the English courts.
From the king, right?
That came from there.
And again, I believe we had a revolution against that king that was doing the exact discrimination against its people. There was nobody stopping the abuse to his people. And again, they said no more kings. So hence the Constitution, the Federalist Papers, the Bill of Rights. And again, most of all, is I cannot find anywhere in anything in the funding of the ADA that gives a carve out to the judges. Yeah. And at that, they take federal funding. They eliminated their 11th immunity. It just doesn't make sense to me. If a judge purposely overlooks your rights and purposely, because guys, don't forget, there's perceived as, there's identified as, there's even the ones that now come in question, can I have help? So you got three obligations there that they have to affirm are working at all times.
How long was that in there for?
But it's all about rules, Henry. It's all about following the rules, not breaking the rules, and making sure that they abide by them, and they don't. And that's it. But if you don't follow the rules, what happens, Henry?
Then we get slammed. And again, we don't have immunity, whether it be in employment or in contracting. I cannot discriminate against somebody when I contract as a plumber. You know what I mean?
I'll get hit for price gouging all the way down the line. Extent of the law, to the full extent of the law.
The way I read it is the president of the United States doesn't even have immunity. He can be charged with treason. And again, this is where I'm trying to lead this to guys. If a judge is breaking your federal, we would have taken them out 100, 200 years ago and tarred and feathered them and ran them out of town. It's again, right. I don't get it. I don't get how the immunity stays when it's blatant and they don't follow their administrative duties. They violate federal funding. In my opinion, it's again RICO, because it would be part of the system to do the cover up to keep costs down so that they can give themselves fat raises and pensions and hurrah parties. And just again, it's crazy. It's crazy, but I don't know. Does Becka want to come in and weigh in on her thoughts on?
She actually had to step out. She had an emergency she was dealing with, so she's not going to make it here with us tonight. So,
well, if you want to give a glance at the first glance of where we're at, but guys, we're looking for people who have input about, judicial immunity. How is it constitutionally correct? If Congress never granted it and it's reaffirmed by their taking of federal dollars, okay, what entity it is, it just doesn't make sense to me.
What do you mean? So what? Let's figure out where judicial immunity came from, Henry.
Well,
let's do this.
It came from English common law, which we all agree we had a revolution. We had a constitution. And in that constitution, separation of powers says that Congress has to delegate who has immunity. The only ones they've done is themselves when it's in an official act to lie.
Right. Which they're very good at.
For public confidence.
Where does judicial immunity come from in the United States of America?
I don't know. What do we only got 2 people watching tonight?
No, we got a few out there.
Because, guys, I really need input from you guys on this.
Immunity in the United States originates from the English common law. It was subsequently adopted and defined as legal doctrine by the United States Supreme Court. Okay, so defined as legal doctrine.
Isn't that by the British Bar Association that would have adopted it? That's who the Supreme Court members are.
It says originates from English common law. So it is not explicitly written into the U.S. Constitution, but rather is a court-created protection designed to ensure judicial independence. Let's take a look at this. All right, Wikipedia is a form. Judicial immunity is a form of sovereign immunity which protects judges and others employed by the judiciary from liability resulting from their judicial actions. It is intended to ensure that judges can make decisions free from improper influence exercised on them, contributing to the impartiality of the judiciary and the rule of law. In modern times, the main purpose of the judicial immunity is to shield judges from the suits of ordinary people, primarily litigants who may be dissatisfied with outcomes of a case decided by the judge. Some countries' judges are immune to lawsuits. I'll never forget the scene of that Lethal Weapon 2, I believe it was it not? The 2, when they were at the Cougar Ant or whatever. And at the very end, the guy turns around and he goes, "You can't shoot me. Diplomatic immunity. Diplomatic immunity." And then they both shoot him in the head. Yeah, that's what I always think of when I hear of immunity. But
I just again, who's immune? Who's immune to the Constitution of the United States? I just don't get how a judge can infringe on your rights and purposely do it and walk away. Now, if he indirectly did it, okay, I give you a little. But when it's put in evidence, put in front of them, and they are chopping it down purposely as revenge because you have the right to appeal. That's what I've been told, guys. The right to appeal. And they know 3/4 of us can't even handle that. You know what I mean?
Yep, sure do. I was just reading a little bit more about this here. The United States, upon independence, inherited from England a common law heritage of judicial immunity. The Supreme Court even holding that few doctrines were more solidly established at common law than the immunity of judges from liability for damages for acts committed within their judicial jurisdiction, notably Bradley versus Fisher. The Supreme Court, referring to dicta to contemporary precedent in England, held that an action ought not to be entertained against a judge for their judicial acts, even where allegedly done malicious and corruptly. The breadth of this view, however, is often disputed. In the United States, judicial immunity is among a handful of forms of absolute immunity, along with a prosecutorial immunity, legislative immunity, and witness immunity. The U.S. Supreme Court has characterized judicial immunity as providing the maximum ability of judges to deal fearlessly and impartially with the public. The justification is as follows: because of the likelihood of an innocent individual being convicted in a court of law under false claims, the burden of being subjected to a court of law, a trial, would dampen the judge's enthusiasm or passion. Opponents of judicial immunity argue that this doctrine is not adequately justified. For example, judges can be shielded from any personal capacity liability, still be subject to official capacity liability, so that they may be held accountable for their injurious acts, thus balancing the evil to better protect the fundamental rights of victims. Judicial immunity does not protect judges from suits stemming from administrative decisions made while off the bench, though, like hiring and firing decisions. But immunity generally does extend to all judicial decisions in which the judge has proper jurisdiction. Even if a decision is made with a corrupt or malicious intent. By the way of counterexample, in 1997, West Virginia Judge Troisi became so irritated with a rude defendant, he stepped down from the bench, took off his robe, and bit the defendant on the nose. He pleaded no contest to state charges, but was acquitted of federal charges of violating defendant's civil rights. Spent 5 days in jail and was put on probation. Because the immunity is attached to the judicial nature of the acts, not the official title of the office holder, judicial immunity also applies to administrative hearings, although in some situations only qualified immunity applies. In determining whether absolute or qualified immunity applies, the U.S. Supreme Court has identified the following factors, according to the Shriver Center's Federal Practice Manual for Legal Aid Attorneys. Significant cases: Stump versus Sparkman, Harris versus Harvey, Supreme Court of Virginia versus Consumers Union, and Morales versus Waco.
Yeah, but again, what about Marbury versus Madison? What about all these constitutional cases that they cannot empower themselves? I just don't get it, man.
Well, where does it say in the Constitution that a man can't empower himself?
The judicial system or the state cannot empower themselves over the Constitution or the Bill of Rights. They cannot make a
Congress
law
can state over this Constitution. Congress
Correct.
can.
Congress one that can delegate.
Right, but Congress and the people can still overthrow the Constitution.
If
via
it's not,
the what do they call that? What do they call that when you overthrow the Constitution or amend the Constitution? You got to have like 3/4 of the Senate or something like that, or old kit and caboodle.
Listen, the 504 clearly says the right to remedy. I'm taking into the fact that the Constitution gave you remedy powers too. Where is the right to remedy if people have immunity and they can blatantly like bite off somebody's nose? It just doesn't make sense to me. You got what? 5 days in jail for doing that? Are you
5 days
kidding
in
me?
jail. Yeah, that's what I was just reading right over here too. 5 days in jail. And I'm looking at these right here. Hard to read here. Misbehavior and integrity approach judicial immunity. Judge acquitted from nose biting, pure shield of judicial immunity. But they're really so. Where does this? So
Again, 1990, ADA was passed. These laws, False Claims Acts were just passed. Fucking what else? RICO statutes were passed. Bullying Act, fucking state policies and procedures are non-discriminatory. Dude, in 2014, they did a hair piece. If you pick on somebody's hair, you could be arrested for freaking civil rights violations. It just doesn't make sense to me.
yeah, I don't know. I don't have an answer for that. The Judges Protection Act of 1985, Judicial Immunity Encyclopedia. There's Webb Thomas E. Judicial Accountability and Public Liability, the German judge's privilege under the influence of European and international law. Pennsylvania judge gets 28 years. Bunch of case law over here that refers to it.
Now, what about the international human rights laws? If a judge is violating somebody's human right, how is that possible? A lower judge. Because again, the ADA was used to create the international fucking UN human laws and regulations. It just doesn't make sense to me. And it ties back to Title VII, which is your constitutional rights.
Yeah.
To be left alone and free and not be intimidated, again, because you're walking with a limp or you got a smashed in looking face because you might have Down syndrome or wiped out on a motorcycle or whatever it is. You know what I mean? I got a friend who's burnt. Burnt. Still shake his stubby hands. You know what I mean? It's my friend.
Right.
I don't see him for having a scary looking hand. But there are people like the 70s where white women would pull up their pocketbook saying a black man's going to mug them, or rape them, something crazy. So again, if we're going to get into that, look at the doctrines that have changed on times of statutes of limitations on rape cases, the Me Too movement. So again, if this country is going across and saying you cannot go beat up an LGBTQXYZ person, you just can't do it. You know what I mean? You got to let a Muslim walk around and say kill America. It's again one. I don't even see how a Muslim has the right to be here and practice law because their true Sharia law goes against our Constitution. You cannot defeat somebody or defame somebody for what they are and what their abilities are. Guys, I'm surprised I'm not getting hammered with case law or other facts of.
Because no one knows what the truth is, Henry. No one cares to know what the truth is. Conspiracies.
We know what the computers are, but every time, this is what the problem is. Every time I try to argue another application of the ADA that bridges their immunity, again, then somebody else's computer tells me I'm wrong. Well, first you have to understand the intent behind this case. And what was in Congress's intent? Congress's intent is to end discrimination against disabled people in any state program, service, or activity. So how can judicial still accept all the money they accept and continue to run with discrimination? They can't. They got to shut down the system and correct it. Hence, the ADA has every 3 years a self-evaluation. Without the administrative duties, well, then who's going to do the self-evaluation? Hence, they've got to sign a piece of paper saying they're compliant to the false claims to get their money. Who's signing that piece of paper?
Right.
This is all information that I don't think I have to FOIA. I should be able to access as somebody trying to navigate the discrimination and get administrative compliancy.
Well, should
and if a judge will not rule on that, because again, they have affirmative obligation.
Yeah.
Wish Becka was here, but she read it in her little computer. It took me 3 days to get her computer to start thinking like me. It really, guys, that's what we did. And again, we ran it through the AI Punisher app
Computer was
that
good.
recognized a lot of things and then made it correct. And again, we're getting stronger on this. So again, if anyone can give any information, that'd be greatly appreciative. Reach out to me. I'll even send you what my theories are because they're educational. This is all educational, guys. I want to
Sure.
know how a state that has no immunity can hire the bar association of your state, and again, their inner tax nonprofit organization that receives federal funding, because don't forget they receive federal grants for indigent people to be represented in certain situations, or criminal to be represented in certain situations, or criminals all the time. You have the right to get appointed by an attorney.
Yeah.
But
Yeah.
again, and I think that's what it was. It was $12.9 billion just for judicial, wasn't it?
Definitely was 12.8 billion. Yeah.
Yeah, something like that just for judicial. I think that's what irritated the shit out of me.
Yeah.
That much money, guys, we could pay each family that goes through the system freaking $1 million and tell them
How
to
much?
see you later.
How much could you pay out of 12.8 billion? How much could you actually pay?
I don't know.
How many people are in the state of Connecticut?
3 million, 3.4 million, roughly. Last I knew, it's not even the population of New York, New York.
12 billion divided by 3 million.
But another argument, and the way I broke it apart, guys, was that my surrounding states have administrations, they have published procedures, they have a case law like McDonald, I think it is, where it's incumbent on judges to ensure the ADA protections and administrative duties are complied with. And again, they referred to Tennessee Lane in that. Washington's own state publicized the rights underneath Bodie versus Connecticut. But when I ran it to the Supreme Court, those justices wouldn't even look at it. How is that possible? And I asked them, our sister common law state. You can go see my recordings, my appellate brief, AC 48057. It has an audio on December 23rd, 2025. You can download it.
Divided by 3 million.
12 billion.
4,000.
It's called.
So it's 4,000. So everybody in Connecticut get $4,000 a year with that. Not a bad
Yeah,
trade.
that math checks out.
It's actually a little more than that because it was 12.8.
Hey, Ara, how much? Hey, Ara, we're on a TV show. We're on Equal and the Same TV show. So be good, please. But how much money does the ADA give to all 50 states per year?
The ADA itself doesn't give money to the states. It's a civil rights law, not a funding program. There's no direct ADA funding that gets split between the 50 states. What you're probably thinking of is stuff like IDEA, special education, which sends states around $14 to $15 billion a year total. That averages roughly 280 to 300 million per state, but it varies by population. The actual ADA enforcement and compliance stuff is tiny by comparison. Mostly small grants for training and technical assistance.
What about for ARO? What about for home and community waivers? What about for the Department of Developmental Services? What about for Title IV funding? What about for all social services programs?
Jammer. All right, you didn't hear that, did you?
Because the courts clearly fall underneath the social service program of Title IV.
No, I didn't hear
UCF.
any. What's up?
Henry, ask her again.
Ara, can you take into the fact that the department...
Ask me whatever you want.
Ara, can you take into the effect that the Department of Social Services funds underneath their Title IV funding and other funding streams to towns and states, how much do they get for the disabled in the OMSED decision and underneath medical costs? Throw it out there.
Isn't really for
Go
Title
ahead.
4E is mainly for child welfare and foster care, not adult disability programs. So it's not the right funding stream for what you're asking about. Want me to look at the actual disability-related funding streams instead?
Yes.
The big one is Medicaid. States get massive federal matching funds for Medicaid services for people with disabilities. Nationwide, Medicaid spending on long-term services and supports for people with disabilities runs well over $200 billion a year from the federal government. That number dwarfs everything else. Want me to break down the per-state averages or focus on anything specific?
Take into what the Department of Social Services gets for funding.
Rough numbers for you. The Department of Social Services, or equivalent in each state, gets the bulk of its disability-related funding through Medicaid. Federal Medicaid dollars for long-term services and supports for the disabled and elderly run around $220 to $250 billion per year nationally. That's by far the largest stream. Other big ones include SSI administration and some HHS block grants, but Medicaid is the main one. Want me to narrow it down to a specific state or keep it national?
Keep it national.
And add things like what they get for parks and recs, protection of the public.
Nationally, here's the big picture. Medicaid, long-term care and services for people with disabilities, roughly $230 billion per year. Parks and recreation accessibility, ADA related, very small, usually just a few $100 million total across all states combined. Public protection, law enforcement accessibility, ADA compliance for police, courts, emergency services, also relatively small, probably under $2 billion nationwide. Medicaid is the giant. Everything else is tiny by comparison.
All right, Henry, here we go. Look at this. Since 1871, the Supreme Court has made available a very broad privilege of immunity to judges of courts of general jurisdiction in civil actions when such actions arise out of judicial acts not done in the complete absence of jurisdiction. In the recent case of Stump versus Sparkman, the United States Supreme Court again considered the defense of judicial immunity and for the first time offered some definition of what constitutes a judicial act. In this author's view, in putting forward a broad definition of judicial act and reaffirming the use of broad construction of jurisdiction in immunity cases, the court assured that the maintenance of a nearly absolute immunity privilege for judges in courts of general jurisdiction when they appear to be acting in a judicial capacity. Sparksman involved alleged violations of plaintiffs' constitutional rights, which were said to have occurred during the process, culminating in Linda Sparkman's involuntary sterilization. Prior to the operation, the sterilization had been approved by Harold Stump, a judge in an Indiana court of general jurisdiction. After a petition, Miss Sparksman's mother to have her daughter sterilized was filed in his court. The petition was granted the day it was presented in an ex parte proceeding without a hearing. Neither the petition nor the order were ever filed or recorded. No notice was given the daughter, nor was a guardian ad litem appointed. The operation was performed 7 days later. Mrs. Sparksman was told she was to have her appendix removed. 2 years later, after Miss Sparksman's marriage, when she consulted a doctor concerning her inability to conceive, she was informed that she had been sterilized. In response, Miss Sparkman and her husband filed a federal action under 42 U.S.C. 1983 and 1985 against Judge Stump, together with a pendent state claim for assault and battery and malpractice against her mother, the mother's attorney, the doctors involved in the surgery, and the hospital where it was performed. Judge Stump's motion to dismiss based on the defense of judicial immunity was granted in the district court, and the entire action was then dismissed. A three-judge panel of the Seventh Circuit Court of Appeals unanimously reversed the district court, holding that the defense of a judicial immunity was not available to Judge Stump. First, because he had acted extrajudicially in ordering the sterilization, and second, because the act in question was performed without jurisdiction. The Supreme Court, however, in a 5-3 decision, again reversed, holding that the judicial immunity defense did protect Judge Stump. The majority and minority views in the Sparksman represent two historical positions on the breadth of the protection, which should be afforded under the judicial immunity privilege, and that these opinions must necessarily be examined in the light of history. Goes on and
Got
on and
it.
on about
You're
this stuff.
Well, send me that hyperlink. I'll see what my research can pull out of it.
It said Bradley was being argued Congress enacted a Civil Rights Act of 1871.
I thought we had Bradley in the brief. Guys, we went through a couple copies today, and then we just said, all right, we're an hour late. We got to launch the show. So this is why we're unprepared.
This is why we're going over it. I'm still
But
here.
again, guys, I stick with the fact that the Constitution never gave it to them. The funding of federal dollars does not give it to them. They cannot grant it to themselves because, again, the state doesn't have 11th immunity once they've accepted the funding to run these program services and activities within the courts. It's clearly attached. There's court funding. I don't care if it's $1 or $2 billion or what was it, 200 billion or 100 billion or.
I understand your point. Yeah, I know. It's frustrating.
Clear absence of jurisdictions and instances where judging it. Yeah, so you got all this stuff. So 1967, in Pearson versus Ray, the Supreme Court resolved the uncertainty regarding the applicability of the judicial immunity defense in actions under Section 1983. There, Chief Justice Warren ruled that a state judge who had convicted civil rights demonstrators of disorderly conduct was immune from liability, noting that he had played no role in the arrest and conviction other than to judge the petitioners guilty when their cases came before his court. The 8-member majority reaffirmed the applicability of the judicial immunity defense under the Civil Rights Act.
But again, if a judge is not taking in the fact that you have no administrative interaction with your ADA coordinator.
Versus Ray, 1967, not Peter versus Ray. That case is actually the first big one where the Supreme Court clearly said judicial immunity applies to Section 1983 lawsuits. The court said judges are immune even when they violate someone's constitutional rights, as long as they're performing a judicial function. You're right that they keep going back to the same idea. If it's a judicial act, they're protected. Keep reading. What's your main point with these older cases?
So is it illegal as a judicial function to fraud the federal government of financial services and program services and activity?
The Supreme Court created and has protected for over 150 years. It may feel deeply unfair, but it is the current state of the law.
What was the law before 150 years ago? Ask her that question.
She's answering it.
Before the Civil Rights Act of 1871, judicial immunity already existed under common law. It came from English common law going back centuries. Judges couldn't be sued for their judicial decisions. The U.S. inherited that tradition after independence. The Supreme Court first addressed it in cases like Randall v. Brigham in 1868, where they said judges generally weren't liable for their acts, though some states allowed suits if a judge acted maliciously. So no, it wasn't created in 1871. The court in Bradley v. Fisher, 1871, and later cases just made it absolute and applied it to Circuit's 1983 lawsuits. The Constitution itself doesn't mention judicial immunity. It's all case law. As for your funding argument, federal money going to state courts or DSS doesn't strip a judge's personal immunity. Courts have rejected that theory. It might help you sue the state or court system itself under the ADA, but it doesn't let you sue the judge personally for damages on a ruling. That wall is very thick.
Then why can a police officer be sued for violating their duties?
Good question. Here's the difference. Police officers only get qualified immunity, not absolute immunity. That means they can be sued if they violate a clearly established constitutional right that a reasonable officer would have known about. Judges get absolute immunity when they're performing a judicial function, deciding cases, issuing orders, etc. The courts treat their role as fundamentally different because they're supposed to be the final decision makers in the system. That's why cops can get sued much more easily than judges. The law deliberately gives judges much stronger protection.
I don't have any more questions. You?
All right, are we
fighting.
going to be able to get rid of judicial immunity?
Not in our lifetime. The Supreme Court has been protecting absolute judicial immunity for over 150 years. They treat it like it's essential to the independence of the judiciary. Even when they've had chances to narrow it, they've chosen to keep it extremely broad. The only realistic way it ever changes is if Congress passes a law specifically stripping it, and even then, the Supreme Court would almost certainly strike that law down as unconstitutional. So honestly, no, it's not going anywhere.
All right, guys, you hear what she's saying. We got to come up with an argument on how to break this apart, because I just can't feel that somebody that's willingly discriminating, knowingly violating the ADA, because again, Congress said no person shall be discriminated in any state program, services, and activities using federal funding. These are real simple words. That's why the ADA has been written in simple language. So it's simple intent. There is no shall, may. It's crazy.
Mm-hmm.
But
here's the hard truth. I said Congress can write all the strong language it wants, but the Supreme Court still says judges have absolute immunity for their rulings, even if those rulings violate the ADA. The court basically told Congress, we don't care how clear your law is, we're keeping this protection.
Ara, the President of the United States does not even have immunity when he commits treason against the United States. And again, when you steal federal funding, you are committing treason.
No, that's not correct. First, stealing federal funding or defrauding the government is not treason. Treason is very narrowly defined in the Constitution. It's only levying war against the United States or giving aid and comfort to its enemies. Taking federal money while discriminating is fraud, not treason. Second, even after the recent Trump immunity case, the president still has more immunity than you think. The Supreme Court gave him absolute immunity for core constitutional acts and presumptive immunity for official acts. Only unofficial acts have no immunity. So even the president has strong immunity protections. Judges have had absolute immunity for judicial acts for 150 plus years. The idea that if federal dollars are involved, all immunity disappears simply isn't how the law works.
Well,
that's it, guys. We got to work out the argument. If anyone's got a chance, because we want to change this, obviously, because I believe it's wrong. I believe that once they've taken federal funding, that their 11th immunity was abridged. They cannot give immunity to anyone. They cannot make a policy or procedure. And that's again with Madison, Mayborough versus Madison.
Anything that's repugnant to the Constitution is there null and void.
Here's the direct answer. Your argument is very unlikely to work. Marbury v. Madison says that laws which conflict with the Constitution are void, but the Supreme Court has repeatedly ruled that judicial immunity does not violate the Constitution. They consider it part of the common law tradition that existed when the Constitution was written. So the court itself has already looked at your core argument that immunity is repugnant to the Constitution and rejected it. You're free to keep pushing the idea, but every court that's heard this argument has shot it down. They simply don't agree that taking federal funding removes a judge's immunity.
But Ara, we used to own slaves in the United States in one time, but we found it to be unconstitutional. So again, to give immunity to somebody to allow them to discriminate would be the same thing, as there is so many policies and procedures out there about discrimination today that weren't there in the early 1800s. Too much of a mouthful. Is she thinking?
Yeah, I didn't realize I was muted. All right, can you repeat that?
makes sense, but legally it doesn't work. Slavery was abolished by the 13th Amendment. The Constitution was actually changed. Judicial immunity was never overturned by any amendment. The Supreme Court has kept expanding it instead. So the two situations are treated very differently in court.
Well, right now that's the best I got, guys. I can't get the argument past anyone.
You're not alone in that. A lot of people have tried the same arguments you're making and gotten the same result. If you want my honest take, trying to sue a judge personally for damages over their rulings is probably the hardest way to fight this. A more realistic approach is to focus on suing the court system itself, not the individual judge, for systemic ADA violations, and asking for changes to how they handle disability accommodations across cases. That's where the law actually gives you some room to work. Going after the judge personally for money is almost never going to work, no matter how strong your argument feels.
I don't want to go after them for money per se, but I definitely feel that the judge cannot be left in a position to continue to discriminate.
That changes things. If your goal isn't money, but to stop the judge from continuing to discriminate, then you should be asking for injunctive relief. Basically, a court order telling the judge to stop doing whatever discriminatory thing they're doing. That's a much stronger angle than suing for damages. However, even then, there's still a major hurdle. The Federal Courts Improvement Act of 1996 generally bars injunctive relief against judges for their judicial acts unless they violated a declaratory judgment first. Still, it's your best shot compared to going after money. Focus your argument on stopping ongoing discrimination rather than punishing the judge financially.
I don't know. I believe the designated responsible employee has the right to remove that judge from the bench and not allow them to continue practicing law against disabled people. Any other society, we keep pedophiles away from children. We keep, bad teachers out of the classrooms. We keep bad officers off the force. What is monitoring the actual judicial canons to say that they have a right to continue to discriminate?
Here's the straight answer. The designated responsible employee, ADA coordinator, does not have the power to remove a judge from the bench. 0. They can investigate complaints about court administration, but they cannot discipline, suspend, or remove a judge. That authority belongs to the State Judicial Conduct Commission or the state legislature through impeachment, not the ADA coordinator. You're right that other professions remove bad actors, but judges are different. They're not employees of the court system in the same way. They're constitutionally independent. That's why they get such extreme protections. The only real mechanisms to stop a judge from continuing to discriminate are judicial conduct complaints, state level, impeachment by the legislature, very rare, of their decisions. The ADA coordinator route simply doesn't have that kind of power. That's the reality of how the system is built.
It's back to the drum, man.
I don't know.
Yeah.
I mean, we know we got on administrative duties, but I feel there's judges out there that are purposely showing patterns of discrimination against people. Some mothers say it's, that they're a woman hater. Some men say they're a men hater, and some just say they're giving the money to their friends and keeping the system going. So it's sort of like I just can't imagine, because if again judicial review, how many judicial reviews hit home? And we saw what was an attorney or law professor on the Probate Trap the other week. He's a nationally known law professor, and he's getting to put up his rear end because the judge can.
Mm-hmm. Yeah, we saw that last week.
Yeah, I hear you. The truth is, there are judges out there with clear patterns of bias or misconduct. The system just makes it extremely hard to do anything about it while they're still on the bench. Judicial review only catches legal errors. It doesn't fix bad attitude, bias, or favoritism. And judicial conduct commissions are notoriously slow and protective of their own. That probate professor you saw getting crushed, that's actually pretty common. A lot of people see it and feel exactly like you do right now. So I'll be straight with you. If you're looking for a clean, effective way to remove or stop a bad judge mid-case, it basically doesn't exist. The system was deliberately built to make judges very hard to touch. You can file complaints, appeal the rulings, and document everything. But expecting the ADA coordinator or Section 504 to get a judge removed just isn't realistic.
But if the coordinator finds that this is a prejudiced judge against certain classes of protected people, he does have the recommendation to recommend to the legislators to auto-correct the system in his self-evaluation every 3 years, and the transitioning plan must take place evaluation
You can
every
even
5
recommend
years.
changes or refer the matter to the Judicial Conduct Commission. But that's where their power ends. They cannot force the removal of a judge. They cannot stop a judge from hearing cases. They cannot autocorrect a prejudiced judge's docket. Their recommendation is just that, a recommendation. The Judicial Conduct Commission or the legislature can completely ignore it, and very often they do. So while the coordinator can document the pattern and push the issue upward, they don't have any real authority to remove or discipline a judge. That power sits somewhere else.
Congress empowered the DOJ and the designated responsible employee to end the discrimination in state program services and activities for the disabled. I don't get it. It's not making sense to me, Ara.
Ask her again, Henry.
Congress in charge, the DOJ and the designated responsible employee 28 CFR 35.107 to end discrimination against the disabled in program services and activities. I still don't get how you don't think the authoritative powers with the settlement agreements across this country of the coordinators and affirmative obligations.
I don't know. She didn't hear that, I don't think.
Sorry.
I don't know, but
Can what?
One more time, Henry.
Congress
Go
in
ahead.
charge the Congress in charge the DOJ. Congress in charge the designated responsible employee 28 CFR 35.107 to end discrimination in program services and activities that are federally funded. I still don't comprehend with all the settlement agreements across this country and the policies and procedures of other states, how the state of Connecticut can continue to ignore their affirmative obligations and judges cover it up. Tennessee Lane says the judge must stop.
Tennessee v. Lane is actually one of your better cases. In that decision, the Supreme Court said that Title II of the ADA can be used to enforce the constitutional right of access to the courts, specifically when physical barriers or policies block disabled people from participating in judicial proceedings. So your core point has some support there. States do have affirmative obligations under the ADA when it comes to access to the courts, and sovereign immunity can be abrogated in that context. The problem is that even Tennessee v. Lane doesn't let you sue the individual judge for damages. It helps you go after the state or court system for systemic access issues, but it still doesn't pierce absolute judicial immunity for a judge's rulings. That's the line the courts continue to draw.
Well, simmer on it. Get back to me by next Saturday, Ara. I need a legal argument to help us break it apart because I have the UN human rights that I just feel nobody can discriminate. Nobody can assist in discrimination. It's like accessory to murder.
I'll give you an honest answer right now instead of waiting. You're not going to win this argument using the UN human rights declarations. American courts treat UN treaties and declarations as non-binding in this context. They don't override judicial immunity. The strongest argument you have is Tennessee v. Lane, arguing that when a judge's actions systematically deny disabled people meaningful access to the courts, It violates both the ADA and constitutional due process. But even then, you'd almost certainly sue the court system or the state, not the individual judge for personal liability. If you want me to try to draft a legal argument for you, I can do that, but I need to know exactly what you're trying to file and in what court.
Ara, for now, I don't want you to draft anything. I want to thank you for your input for the show. And again, I hope people are going to be able to mull this over themselves. And again, I'm going to show you my thoughts and reasonings on another air date. But we will be talking soon, ladies and gentlemen. Darren, thank you for another interesting night.
Yes, sir. I'm glad that I could be here with you and bringing Ara home. I'm going to take her home now and, put her to bed.
Well, it's tough work trying to save the world.
Always is, my friend.
Again, appreciate everybody for tuning in tonight. Same time, same channel next week.
See you then, guys. All right. See you then.
One man is lost in the
Good
fog.
night, guys. Take care.
His friend brings a torch in the night. They walk arm in arm through the dark, guided by one man's sight. One man's sight. Some cannot walk, some cannot see, some cannot speak, some cannot hear, some cannot learn, some cannot think, but all can love, and all can feel, and all can care, and all can change, and all can learn, and all can grow. We are equal in the same. We are equal in the same. We are equal in the same. Two men were working the land, two farmers making their trade. And while one was blind, he was still the mind behind the world's best lemonade, his lemonade. Some cannot walk, some cannot see, some cannot speak, some cannot hear, some cannot learn, some cannot think, but all can love, and all can feel, and all can care, and all can change, and all can learn, and all can grow. We are equal in the same. We are equal in the same. We are equal in the same.
They said don't fight the system. They said stay quiet. They were wrong. Lock in. We are exposing what so many have failed to. We are gonna
show you what bar attorneys have hidden from all of us. Hundreds of thousands of children and twice that of parents have been lied to and walked down the road of termination. It's the death penalty. We're all of the protesters, the ones who fight for the rights of prisoners, dogs, illegal immigrants. Why aren't you coming to the aid of our children and families? Right here in America, every day a child per minute is kidnapped. And no one cares. We fight alone until today. CPS punishers mount up. Here comes the CPS Punisher.
Anonymous tip, another lie from one of them. No warrant, no proof, just a badge and a grin. Stealing kids like trophies, thinking they'll win. Mama crying on the porch, daddy in the cage. System wrote the script, but the CPS Punisher just flipped the page. The educator they banned, I see every violation, every forged line, every ex-part hearing, every stolen time. One tap of the app and the truth ignites. Welcome to the CPS Punisher, now we can fight.
CPS and the courts have lied to us all.
The courts will not disgrace the family.
CPS Punisher, here to avoid the chains and expose the game. CPS Punisher, the educator they never wanted you to find. Punisher, one tap and their empire cracks. We realize we take our kids back. The app is called the CPS Punisher. I'm the cape in the shadows, the skull in the night, the binder full of secrets, the weapons you all need. Ab initio, watch me void that lie. Fourth Amendment armor, watch the tyrants cry. Falsified drug test gone in a flash. I see Tevio, warrior, due process king. Every parent's hero when the hotline rings. I call it justice. Download the truth, now the system busts us. From the courtroom to the streets, hear the battle cry. The CPS Punishers arrive. Kiss your bar asses goodbye. They tried to silence us, now we're the loudest voice in the room. CPS Punisher, here to avoid the chains and expose the game. CPS Punisher, the educator they never wanted you to find. Punisher, the children never leave again. Punisher, families rise, we never look back. We now use the CPS Punisher. This ain't revenge, this is reunification. This ain't rage, this is resurrection. Open the app, step into the fight. You ready? CPS Punisher, the app you need when they took your kid. CPS Punisher, the truth they hid, now the truth gets lit. Punisher, download the power, take back the throne. Punisher, you're never alone. CPS Punisher, the educator they never wanted you to find. Void complete, family restored. The bar is finished, the Constitution will prevail. Judges do what's right. Treason is your penalty.